I will call this meeting of the Senate Judiciary Committee to order on April 26th of 2021. Will the secretary please take the roll?
Vice Chair Cannizzaro.
She is on her way. Will you please mark her present when she arrives?
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemyre. Here. Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here. We have a quorum present, and that allows us to begin our business for the day. Welcome again to a hybrid, in-person, via the internet committee meeting of the Senate Judiciary Committee. We have 4 bills to hear today with some special guests from the Assembly. I'm going to take them slightly out of order, but we are going to start with AB 115. Assuming all of our presenters are here and ready to present, I'm opening the hearing on AB 115 right now.
Thank you, Chair. May I begin when I'm ready?
Yes, please, go ahead.
It's probably all the electronics here now that we are in here too. Hello, everyone. Rochelle Wynn from Assembly District 10 for the record. I am here to present Assembly Bill 115, which revises provisions relating to parentage. I'm just going to give you a little background information and then turn it over to some of my co-presenters, Mr. Wade, who is on the line, is on the Zoom, as well as Ms. Surratt, who is here presently to answer also additional questions that you might have. Here in Nevada, families often have more than 2 adults that actively are engaged in parental duties and responsibilities. These families should be afforded certain legal rights and options to maintain stability, protect their families, and ensure the family relationship is recognized by law. Children often experience significant trauma when separated from a parent as a result of the law not recognizing the nature of such families. As such, in states like California, the California Legislature in 2013 passed similar legislation that most children have 2 parents, but in some cases, children have more than 2 people that are a child's parent in every way. And separating that child from that parent has a devastating psychological and emotional impact, and the courts must be given power to protect those children from that type of harm. The existing law only allows for 2 adults to be formally and legally recognized as parents, and this bill proposes to amend existing law and allow for 3 adults to be formally and legally recognized as parents without having to terminate the rights of any other parents. If you do have the opportunity, we did have Devin Reese, Reno City Councilman, that testified in the Assembly. Unfortunately, he was not able to be here today, but I would encourage all the members of this committee to, if you have the opportunity, to watch that proceeding in the Assembly because his story is very powerful. I think of this as affecting families and maintaining the family relationship. God forbid anything happened to me or my husband, and our 2 children, Henry and Hannah, who are ages 9 and 11, were put into a situation where they had multiple grandparents that wanted to take care of them. This law and Assembly Bill 115, if passed and made a law, would allow all of those grandparents to take a role in my children's life if anything was to happen to us. And that's what this bill does. It recognizes parents that want to take that legal and formal responsibility for children and incorporate that into Nevada law to protect Nevada families. With your permission, Chair, I would like to share some of my time with, I'm not sure what order they're going to go in, but I think I'm going to start with Andre Wade, the State Director for Silver State Equality, and if I could turn it over him to make a statement in support of Assembly Bill 115 as a part of the presentation.
Absolutely. Thank you, Assemblywoman, and please go ahead whenever you're ready, Mr. Wade.
Thank you, Assemblywoman, and thank you, chairs, co-chairs, and members of the committee. Again, my name is Andre Wade, A-N-D-R-E-W-A-D-E, and I'm State Director for Silver State Equality, a Nevada-based statewide LGBTQ plus civil rights organization We bring the voices of LGBTQ plus people and allies to institutions of power in Nevada and across the United States, striving to create a world that is healthy, just, and fully equal for LGBTQ plus people. So parenting looks different for every family. There are single-parent households, two-parent households, households with step-parents, and there are situations where children have more than two parents who are actively engaged in parenting duties. This often happens when a step-parent desires to legally take on the responsibility of caring for a child in addition to the natural birth parents. Yet another example may include two women in a same-gender marriage who form a family with the help of a male friend who is not only willing to help with the women conceive a child, who also wants to fully parent the child with the couple by sharing the equal duties and responsibilities of caring for and raising the child. In these situations, families should be afforded certain legal rights and options to provide stability, protect their families, and ensure their family relationships are recognized by law through adoption. According to a brief released in February by the United States Census Bureau, the American Community Survey determined that Nevada is one of 11 states plus the District of Columbia with a higher percentage than the national percentage in 2019 of same-sex couple households. Although census data does not capture households where multi-parent situations occur, and because only relationship to the householder was collected, we do not know that same-gender couples are more, but we do know, same-gender couples are more likely than their opposite gender cohorts to form families through adoption. Moreover, a significant number of states are recognizing that children have more than two parents. A number of these families moving to Nevada may involve children who have more than two parents and are in need of legal protections to ensure their safety and well-being. AB 115 will help create uniform and consistent parenting through laws throughout the state, decrease situations where only a select number of judges allow multi-parent adoptions, and decrease situations where only parents with financial means can access the right judge to form their modern family through adoption. Also, the law can prevent situations where a child is separated from one of their parents due to a lack of clarity and protections in the law, thereby resulting in a traumatic situation for the child. So with these provisions in place that we are going to be talking about today, we know that the best interest of children being cared for by more than two parents will continue to be the center of how modern families are formed by way of adoption. This ends my presentation. Thank you very much.
Thank you. And Chair, additionally, if I could turn this over to Kim Surratt, I know many of you are familiar with her because anytime anything comes up with family law, I know she is my go-to person. She does serve on the family law section of the State Bar of Nevada, but she is here in her private capacity here today. I know that she has been just crucial in helping me try to get the language right and the intent of this bill on the record too. So if I can turn it over to her for some further statements and also to answer any questions when the time comes.
Absolutely. Please go ahead, Ms. Surratt.
Thank you, Chair. Hello, Senate Judiciary. I'm Kimberly Surratt. I'm a private family law attorney. I'm also the president of Nevada Justice Association. I just finished my 8-year term on the Family Law Executive Council at the State Bar. Thankful to be done with that term, actually. It was a lot of work. As stated, I assisted with the language in this bill and also helped testify as to each of the sections. With your permission, Chair, I will give some guidance as to what the language is. Starting with I'm just going to go straight to parts where we have amendments. Section 3 just clarifies what the intent is that as we go through the bill, but it's not the substantive part of the bill, quite honestly. Section 5.2 is where it starts with the most pertinent language. In the past, the old language under NRS 127.030 stated that you could only have any adult person or any two persons married to each other to adopt. Prior to domestic partnerships and same-sex marriage that caused a lot of problems in our state and caused a lot of judges to even state that we could not have a same-sex marriage. Marriage has been cured, but what has not been cured is the ability to have a third parent on the birth certificate and or the ability for unmarried individuals to adopt. In my practice, I do a significant amount of this work, and there are many examples that I can go through, but the highlight examples would be scenarios where, as Assemblywoman Wynn stated, would be, both parents have passed away, and we now have grandparents on both sides of the family who know that they can't take care of the child 100% of the time, but it is best for the child to stay within the family. We also have scenarios with step-parents. I have a significant number of step-parent cases that come in front of me where the biological parents or legal parents of the child would like a step-parent to be able to adopt and also be a parent, and I don't have the ability to do that. That was the example given by Reno City Councilman Devin Reese in the Assembly side, as his wife, his ex-wife, Emily, had passed away, and his partner, she wanted him to be able to adopt. That adoption was not possible until after her death from cancer. And after her death, the birth certificate has never been amended because the children don't want their mother removed from their birth certificate to add their new step-parent. In other examples, we've had situations where an individual has raised a child believing they are biologically related to the child for up to 10, 12 years of that child's life, and suddenly there is a controversy within the marriage, and perhaps biomom brings out the actual genetic father of the child, and really we had 3 people who, the person who thought they were genetically related to the child and thought they were a parent to the child doesn't want to be removed, doesn't want to not have parental rights. The only option we have for these families is our third-party visitation chapter. And that third-party visitation chapter is a very limited chapter. It's limited appropriately based on constitutional rights of a parent to be a parent and make decisions about who the child spends time with. But when you have families that are willing to consent to the adoption and willing to raise that level of parental rights to an adoption level, they should be able to do that. The third-party visitation chapter says you have to be completely cut off from a child before you have standing to even use the chapter. So if they're seeing the child once a month when they were raising the child 24 hours a day, 7 days a week, that 1 day a month is sufficient to prevent standing. And I've had extremely nasty litigation cases with third-party visitation where they've wanted that person to stop being called mom or stop being called dad as part of that petition process. And it's really quite gross, honestly. It's some of the worst litigation I've been in. And oftentimes it parallels a divorce litigation anyway, so you got 2 separate actions with heavy amount of attorney litigation happening in the case. There is a proposed conceptual amendment to Section 5.2, and this was based on my communications with Senator Pickard, and that in the intent within the Assembly and within the language was that if there are legal parents to the child, they have to be a party to that adoption. They have to be consenting to it. This isn't a force the adoption on parents that don't want to allow in a third person. So there's been discussion regarding that language. I believe the amendments to Section 5.2 clean up that language. I'll discuss a separate issue in a second regarding that, but hopefully it makes it clear. I know the legislative intent is the legal parents of the child, and I'm not using bio because they may have adopted to start with or used reproductive technology, so we don't want to use biology as the marker for that. But the legal parents have to be petitioners to the case. Whether we use the word petitioner or party, there's discussion to be had about that. They need to be a party to the case. As you go on through the bill, later in Section 5.2, subsection 6, this came out of the testimony on the Assembly side, where discussion was had about things that are frustrating in these adoptions when we have step-parent adoptions and the process. And the discussion was, well, the most frustrating part is paying for an attorney to have to go to a hearing that lasts all of 5 or 10 minutes. And they used to drive down to the courthouse to participate in that hearing. Of course, it's a little bit easier right now with Zoom. But in a lot of those cases, with second parent or step parent, depending on what language you're utilizing, or third parent now, if the court deems it necessary to waive the hearing, we would like the court to have the discretion over that, and that came out of the hearing on the Assembly side. Section subsection 7 under section 5.2 is just additional clarifying language about the intent of the bill. We now move on to quite a few changes throughout most of the rest of the bill, which is really just that issue I just mentioned about legal parents versus the bill used, the whole chapter used the word natural parent, which really wasn't actually defined. And we don't use that term natural parent in other chapters, family law chapters in NRS. So we're trying to get down to what we really mean, which is the legal parents of the child. Under section 5.65, additional language was added there, language that needs to be in the petition for adoption. This is not on point with the issue of multi-parent adoptions, but it was added at the request of Assemblywoman Tolles, who was concerned about human trafficking issues within adoption in general, in the broader picture of adoption. And we discussed adding this as a requirement within the petitions. We know, and in my discussions with Assemblywoman Tolles, we know that it won't stop human trafficking by asking somebody to put this into a petition for adoption, but we're hoping to raise awareness by having it included in the adoption petitions with Assemblywoman Tolles and I to have future discussions between session about additional changes to the adoption chapter to continue to strengthen the defense against human trafficking. In the next conceptual amendment, which was to section 5.8, that is the new amended language. Again, it was an effort to achieve the legal parents language, and in that, it was pointed out to me that we had a obvious mistake where we had mentioned consents, but we didn't mention relinquishments. All the difference is that a relinquishment is to an adoption agency or social services, and a consent is a private consent in a direct placement adoption that doesn't utilize agency services. And they actually are two different beasts. They are treated differently. Social services and/or the agency gains greater control over the child through the relinquishment process, but the amendment is purely to add in relinquishments that should have been added into the language to start with. I think that's all of the substantive sections to discuss. There was some discussion regarding the issue of parents being a party to the action and whether or not additional sections should be added to clarify how that would work or to allow it to work. The reality is adoptions are multi-person petitions to start with. We often have more than one party because by their own nature, a lot of times couples are already adopting, right? And we already have two parties. So by saying that the legal parents have to be petitioners, I believe the intent and the legislative intent is clear on that, and that trying to create some new beast of a provision just for that joint petitioning process, my concern is that we'll make mistakes and not pull enough of the other language in from the adoption chapter. With that, I'll take any questions. Just spit out a whole bunch of info.
Chair, I have one other person to present, Rochelle Wynn for the record. At this time, I would like to put some context. I think it's always important to look at how this bill potentially can influence actual Nevadans. So I have a Nevadan here that happens to be one of your own. So if I can have Senator Harris come and provide her testimony.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Dallas Harris, representing District 11, and I just want to tell you all a little bit about my fantastic family and how in 2021 things are looking a little bit different, and our laws need to be flexible enough for that. So in 2019, I got married to a wonderful young woman who has a excellent, smart, gregarious, very handsome, if I do say so myself, son. named Lawrence, who is now, as I'm sure you all would expect, my son as well. We all live together. I wanted to get this, I didn't submit a testimony in time, but I'll just try and put up a little photo. Oh, take off the shield. Good call. Take off the shield. This is us.
Let the record reflect that Senator Harris is showing us a very adorable photo of
And that
herself.
he is actually handsome.
Yes, yes.
So this is us. Lawrence has a father, as I imagine you all would expect, who my wife was married to at one point, but is very much involved in Lawrence's life. He is Lawrence's father, and none of us have any expectation of taking that away. And let me just show you these two handsome fellas. They spend multiple days together a week. He's very involved. He does a great job. He's a great role model for him, and none of us have any interest in taking his parental rights away. Here's where this bill comes into play. As it stands right now, I have no legal parental rights for Lawrence. And if something were to happen either to his mother or his father, God forbid, both at the same time, legal difficulties would ensue. And so I wanted to come before you all today and let you know that if this bill passed, I would be first in line to getting some parental rights for Lawrence so that he can have 3 parents legally. He's already got it in practice. But I want to be on the books. His mother wants me to be on the books. His father wants me to be on the books. I get all the school emails. I tried to go for career day this year, but legislative session got in the way. And so it's time that the law actually conform to what a lot of families in Nevada are doing. There is no reason why we have to limit the parental line to 2 folks anymore. We've got the court process to make sure that things don't go out of off kilter and someone's got 10 parents, or that the child is harmed in any way. Those protections will remain in place. There are just some of us who are looking to formalize the relationship that we all have in our hearts. Thank you.
Thank you so much, Senator Harris. And Assemblywoman Nguyen, does that conclude the presentation? She's nodding yes. So we will move on to questions from members of the committee. I know that Senator Settlemyre has one. Go ahead.
Thank you, Chair. I appreciate that. I appreciate the bill and the concept. We have so many parents out there that are helping to raise sometimes other people's kids through either deceased or just circumstances. In that respect, I appreciate the bill. I'm questioning a little bit of the mechanics of it. Who decides who goes on to the birth certificate? Can the mom elect that at birth and name 2 extra individuals, or however many in that respect? Or is it a situation after the fact in a court process and the judges who does it after a person petitions for that, or how does that work?
Right, thank you. Madam Chair, Kimberly Surratt for the record, to you, Senator Settlemyre. It depends on how that child was created. If it was, for example, the scenario like Senator Harris's family, then it's after the fact and it's an adoption. If it is through reproductive technology, our assisted reproductive technology statutes that we passed in 2013 are already gender neutral, number neutral, marital status neutral, but we didn't have the mechanism with Vital Records until we had this conversation regarding this bill. Vital Records has promised us that it is not an issue. We didn't receive a fiscal note from them. They know they can achieve it. We provided them with sample birth certificates from other states who have had de facto parenthood type language on the books for a lot of years where they could find 3 parents. And we're in good shape with them on that. But a lot of these will be through this chapter, it's just through adoption, and it would be after the child's born, and depending on the circumstances. With a lot of my same-sex couples, if they use reproductive technology, I've also had another bill in another session for affidavits of parentage. Instead of paternity, we also added in parentage, and that allows them to fill that form out at the hospital to both be placed on the birth certificate, and the way you would if you were an unmarried opposite-sex couple and you swore through your affidavit of paternity, this is the father. They don't do a genetic test, you just fill out that affidavit. It has the same effect as an order.
Okay, I guess that brings another question, if I could. Then what do you do in a situation where the mom, in her opinion, she knew who the father was at the time of conception, but since then had established a relationship with someone, and they were the person that was also added, so you had two fathers on that, and then unfortunately, let's say a couple years later, it didn't work out. And then she goes after child support. How does that work out? Do both fathers pay because both fathers are the father? How does that work out?
Senator Scheibel, Chair, Kimberly Surratt for the record, to Senator Settlemyre. Yes, the contemplation is that child support will apply to any parent in this scenario. The State Child Support Commission will have to take a look at the language and determine if any changes are needed to that. I am the chair of that commission, so I will have it on the agenda. But quite honestly, the way the language is written within the child support chapter, I still couldn't see where too many changes are really needed, other than a little bit of gender neutralizing type language. And it is possible that both parents will need to pay some child support.
If I continue on, would that be joint and separate liability, or just?
Kimberly Surratt for the record. Based on the other states that have had three-parent adoptions, yes, there have been, it becomes an issue for the court. It's the discretion of the court to determine what's happening. It may be based on, the scenario where the genetic dad comes out of the woodworks 15 years later, has no time with the child, doesn't have an interest of time with the child maybe, and determinations will be made as appropriate for the child based on the best interest of the child.
Okay, that just brings up obviously another host of questions on the concept of joint and separate liability. So then you're saying that even though both of them are the father, there's two fathers, that one's biologic and one helped raise, and they're both materially responsible for making sure that this person is taken care of. You're saying that one person could potentially have 100% of the economic burden and the other person not? You're saying that could be a decision of the court?
Kimberly Surratt for the record. That'll be dependent on what the custody arrangement is and who has custody of the child. When we have joint physical custody, if the court determined that it's in the child's best interest to have time with all three parents equally, which I doubt would become the best interest of that child. Probably the actual reality of that scenario is that there were two parents that child was spending the most time with, right? And the one that came out of the woodworks doesn't even know the child. So back to best interest of the child, and if it's, depending on the split in time, if mom had primary custody and the other two had, I hate using the word visitation, but that's what it is.
I guess let me
parenting time.
go further into the weeds. It doesn't matter. If you are the biologic father, you have a responsibility to take care of your child regardless of visitation. So I don't see where the visitation discussion comes into it necessarily in that aspect. So I guess I'm going to have to try to follow up offline and try to get more information. And then the last one that I have unfortunately seen is where sometimes a woman, after having a child, will not put anyone on the birth certificate. And then the father, who actually wants to have time, has to actually go into a court of law and do a paternity test on the mother in order to have time with their own kid. And that's, I don't know. I'm going to have a lot of questions offline. Sorry about that. Thank you.
Rochelle Wynn for the record, if I could just respond, I understand that there are other scenarios and other circumstances that are outside of this. The intent on this bill is for parents that want to be a part of their children's lives in a legal sense. You have many families that are like Senator Harris's family, where both consenting, I guess, natural parents, legal parents, to a child want to have that other parent recognized formally. So the intent of including this is to allow for those parents to accept and have all of those legal responsibilities and even those outcomes later on should the relationship between the parties crumble, that it is our intent in this language that they would be full legal parents, and so they would be responsible for child support, visitation, any of those things. And so that's the intent in this legislation. Obviously, it sounds like there's some other issues that go on with regards to paternity and other things, but that's why we wanted to contain this in the adoption statute.
If I may
Thank you.
follow
Appreciate that.
up. Thank you, Chair. Kimberly Surratt, for the record, this doesn't fix all those problems out there. There's lots of scenarios where people have to fight for their parental rights. These are really the people that are consenting to it. Senator Pickard had an example for me too, where I said, well, yeah, they could have used the old law even for the adoption chapter because it was just two people, but unfortunately, this is a narrow window. It is the people who sign up for it and agree to it mutually as a team. And if they're subject to brutal child support wars down the road, they signed up for it, they raised a child, they had intent to bring a child into the world, and guess what? They're responsible. But
I appreciate those answers. I just worry about the concept that sometimes you consent in the beginning and sometimes not so much consent at the end. Thank you. I have to.
Thank you. Yes, and I was just going to, for the record, excuse Senators Settlemyre and Hansen. They are not fleeing you because of your answers to the questions, but they have bills to present in another committee, and I'm sure they will follow up with you offline. I also wanted to get something on the record for clarity's sake, even though Senator Settlemyre does have to go present his bill elsewhere. Are there already situations in family court where more than one person might be responsible for child support payments, be it because of a legal adoption or because of a certain amount of time spent with the child or assumed parentage? Is it novel to suggest that we might have a situation where there's more than just one person in question?
Kimberly Surratt, for the record, Chair. I've seen it. I've had it in cases. There's, the beast of family law is that every family in the state has different circumstances and situations. You may have guardians collecting child support from two legal parents because the guardians had to take over custody over the child. I've had lots of different scenarios. At the end of the day, though, for time with the child and your rights to be able to see the child, we're much more flexible on collecting money from people than we are on their time with the child. And they tend to turn into nasty litigation.
Thank you. Any other questions? Okay, we have a question from Senator Pickard. Please go ahead.
With your indulgence, Madam Chair, I have lots of questions. I won't get into all of them. But as the two practicing family lawyers here with more than a decade of practice in this area for each of us, there are many different facets to this. And so I want to acknowledge, number one, that I agree with you to the extent that if we have a joint request by parents, particularly in blended families, I don't think gender in this case really makes a difference, same-sex marriage or otherwise. I'm in a blended family, and I raised some of my kids since their toddler years. I was as much a parent as anyone in their lives. And so, although I do not enjoy the status of parental right or one possessing parental rights, I was, in fact, more involved than some of the others. But that's not what we're arguing about today, or discussing is what I mean to say. And I appreciate, Ms. Surratt, your taking the hour or so yesterday to talk to me about this. So I just want to touch on a couple of things that you and I spoke on, and that is that I agree that where all parties agree, then I don't have a problem with this, because that's at the outset of the relationship. We end up in a situation where the two natural parents, to use the terms of the existing statute, are in agreement with allowing this third party to come in. We also see that in surrogacy cases. We also see that in open adoption cases, where a party is technically relinquishing their rights to 432B cases, or under a normal family law case, they're terminating their filing or signing a consent to termination in order to allow a step parent to adopt, because everybody, all three, agree that this is in the child's best interest. Then, at the end of the day, if that relationship comes apart, we have a pecking order, a priority status, and the person who has relinquished their rights or have terminated their rights has a lesser standard because they agreed to the idea that it was in their best, in the child's best interest in the beginning. This, however, I think would change that. So to continue our discussion a little bit, under section 5.2, we're not, and even with the proposed amendment that you've provided, the joint petition, as we've learned from many, many Supreme Court cases, and I'm thinking of Rivero 2 and Schwartz v. Schwartz and Potter v. Potter, where the legislature has not created the structure and guidance for the courts to follow, particularly where we're talking about, this bill doesn't talk about any of the best interest standards that would
Senator
apply in these cases.
Pickard, I'm going to ask you to focus in on a question for one of the
I'm getting
presenters
there.
to answer.
I'm getting there. This is just to get some of the conversation on the record so everybody understands the basis for the question. I mean, the problem we face is if we talk in technical terms, it loses everybody else. So we've kind of got to water it down and dumb it down so that that's the wrong term, but
Senator
simplify it.
Pickard, we have 3 attorneys on the dais right now and 2 at the table, and I think we're perfectly capable of understanding your questions. If
Great.
you would go ahead and ask it, please.
Thank you. I am. So, with this as a backdrop, we have this existing Supreme Court direction that the legislature is supposed to be giving guidance to the courts. How is it that the term joint petitioner without the structure of a joint petition, which is not allowed under this bill or under current law, how does this advise the court how to manage that case?
Kimberly Surratt, Chair Scheibel. To answer your question, Senator, the joint, I think the problem is with the word joint because of the fact that we have the other chapter, other statutory structure for a joint petition for divorce. It's its own beast. We happen to use the term petitioners within adoption orders or decrees, right, and petitions. We already have more than one party in most of those petitions. Mm-hmm. And we don't have to use the word joint for 2 people to adopt because the language said any adult or any 2 persons. We've allowed the multiple persons, and we've also said, but if you're also keeping your rights, you need to be a party to the case, and you've got to consent. The statutory structure behind a joint petition for divorce, for dissolution of a marriage, is a very different legal beast because, as you're aware, it causes you to waive a new trial, an appeal, and there's very specific things to it. I don't want to try to create a joint petition for adoption and ignore 90% of the adoption chapter and accidentally not pull in all the pertinent, relevant pieces of the adoption process that still needs to be part of it, which the chapter still applies. It's just now, instead of any adult person or 2 persons, we're now on to 1 or more adults. And that language existed without having a joint petition language in the adoption chapter to start with.
No, I agree with that. However, these situations only become problematic when they're being litigated at the termination of that relationship, where the parties are splitting up, and now we have to divide the time with the child across the multiple parents. I mean, the thing that comes to my mind is what happens now when you've got 3 people who are now fighting over custody of the child, and now you have multiple people with standing and equal parental rights. How do we divvy up without guidance to the court, how do we divvy up the time with the child? We're not addressing those parts of the statute, and so we're giving the courts no guidance as to how to address the parental rights of each parent. So we start with the assumption then, by the way this is structured, that each parent will have equal parental rights, no?
Yes, sir.
Okay,
Kimberly,
so without some kind of guidance as to how we structure those rights, particularly since we don't address, for the example, not necessarily the parent who comes in without having had any contact, but what about the parent after, post-divorce? They are a non-custodial parent, so maybe they've only had every other weekend and the occasional time during the summer. So significantly reduced time. And now the new set of parents with the new parent, they are now divorcing. And now we're in a situation where that person hasn't had those rights. Can't he collaterally attack this relationship?
Kimberly Surratt, for the record, Chair Scheibel, to Senator Pickard. Yes, but every single one of our family law cases goes on best interests of the child and are just as complicated and nasty. And I don't personally believe that just because there's a third party that had actual legal rights versus the nasty cases we have in third-party visitation chapters, separate and apart from the divorce, where they may not be talking to each other and where they get truncated and or told they can't be called mom or dad anymore, or any of the other nasty repercussions. I'd much rather have a complicated matter within family court that's one matter for this child, for that child's best interests.
All right.
And I think our principles are intact for that.
I guess that is going to be a point of disagreement, if only because, and I agree with the position you're starting in, right? Where we're trying to make this a situation where parents who want to be parents get to be parents. I'm with you on that. Having been one, I get that at the most visceral level. I'm just thinking as a practitioner, doesn't this make it more difficult then for the court now that we've got 3, maybe 4 people that are engaged in this litigation? I'm imagining 4 desks with different parties, different. This is going to look like a construction defect case where we've got multiple angles of attack from 4 different, potentially 4 different parties. I don't know, somebody has said more than that. I can't envision myself a situation that would be more. But won't that make it harder to determine? And the best interest factors under NRS 125C0035 sub 4 don't address any of these situations specifically. They're more broad. So won't this make it harder for a court to determine what is actually in the best interest of the child?
Kimberly Surratt, for the record. I've had those cases without this chapter. I've had them with grandparents in the room, parents in the room, potential adoptive parents in the room, and I've had attorneys all the way around with CAP attorneys for the child and guardian ad litems, and they exist. They already exist. They just get truncated rights and in terrible outcomes. And so with this, at least we know where they're standing from. They at least have a fighting chance. And those cases exist. The litigation's out there. The number of people that are going to opt into this are not going to be the ones that are the most contentious and are fighting as much, right? They're
Yeah.
going to be people like myself and my ex-husband who works in this building and has an amazing new wife who I love and adore, and we're not going to be those people, right?
And I think there are also things that we wanted to make sure that we got to that, even before we are looking down the road on when things crumble. Because I realize as a practitioner, that's where your mind goes, because that's usually when you see the cases. You don't see them as frequently on the front end when people are trying to become these families and trying to be recognized legally. That's why you have to have consent of all the parties in order to get it. That's why even after the consent, you have to go to a judge, and a judge has to make that determination. So that's why, like, I agree with you. You're not going to get a judge that, you're not going to get like you're not going to get 40 parents that are in a room wanting to adopt a child and then later having to dissolve in like equal custody amongst 40 parents or even 10 parents or even probably not more than 4 parents, to be quite honest, or legal parents. And so I think that the process that we have in place and the intent that we're making in the record here today in the Senate as well as in the Assembly is that these are consenting like adoptions. These are situations where everyone has to consent, and then the court also has to agree with that, with the protections and the like conversations that we've had about like, abuse or any of those things. So there has to be that kind of conversation. So if you got a situation where there were 6 parents, to be quite honest, that wanted to recognize legal guardian, and 5 of them all agreed, a judge would still have to look at that and say, is this in the best interest of the child to agree to this consensual adoption to have all these multiple parents? So, that's kind of the intent there. When we first introduced this language, it was in the wrong chapter, and if you look at the Assembly side and what's come here, we did remove it into the chapter, worked with LCB, worked with local practitioners to try to overcome some of those concerns that you're expressing here today. So hopefully we'll get there. I know it is continuing to be a dynamic document. Obviously, we have some other conceptual amendments that we'll be working if we are fortunate enough to have a work session in this House on the bill.
Well, I appreciate that, and so we can pretty much leave that part. I think we've hit it enough. I think that the difference between what you're describing, and I agree, I've had all the cases, or most of the cases you haven't done any surrogacy work, but aside from those, I've done those nasty grandparents jumping in and all that. But we had the starting point of there were 2 people, and only 2 people, that possessed at any given time the parental rights, the ultimate right to be able to determine what's in their child's best interest. And this would undo that. Moving on then, why are we limiting a waiver for a hearing to the 3rd degree of consanguinity? Can you explain why consanguinity applies here?
Thank you. Kimberly Surratt, Madam Chair. Because those are the ones that are based on consent, and I still left it to the court to have discretion to waive it, because I think when they see a 3-parent adoption, they're going to want to have the hearing. And I wanted to keep that intact. It's kind of the reason I didn't want it to be, just to use the language from a different discussion about a summary disposition of it. I don't want it automatic, where it's just automatically granted, because I think all this has to be taken into consideration for the best interests of the child. When a child is adopted out of when they're not 3rd degree of consanguinity, there has to be an investigation and report that has to go in front of the court. A hearing has to be had in order for all that to be accomplished. You can't get around that.
Okay.
You don't have that in the 3rd degree of consanguinity cases. Well, you could. A court could say you have to, but you usually ask for a waiver, and you typically get one.
Right, and in my experience, you almost always get those waivers, particularly where everyone's consenting anyway. In section 5.8 is different from section 5.3 in that it only deals with terminations. You talked a little bit about the difference between relinquishments and terminations, and I appreciated you getting that on the record. Is it your intention to modify the statute to provide for termination once the parent, without the others, including the biological parent?
Kimberly Surratt, for the record, Madam Chair. There, on consents and relinquishments, there's a whole set of statutes within this chapter that deal with when they're valid and when they're not, and when they can be revoked, which is a very narrow window, and all of that staying intact and has not been touched. And so when I added it into this part, I took a really good hard look when you pointed that out to me to make sure it wasn't just specific to consents before I added the relinquishments in here, because there is a little bit of difference when the agency takes a relinquishment, they get more control than in a consent scenario, and I wanted to make sure it was appropriate right here, but I kept it intact. All of the validity of the consents and relinquishments are still.
All right, perfect. Thank you. And then section 8, last question. Section 8 deals with extending parental rights to any person who has a parent-child relationship. And I'm thinking under, and we kind of touched on this a bit, NRS 125 CO50 establishes that a non-parent may obtain visitation rights after proving that a child has established, and under the statute it's called a meaningful relationship, and we've used that elsewhere. However, they are limited to visitation and they don't extend to parental rights. Doesn't this section tend to change that, the parental preference in custody matters under the 125 CO50 standard?
There is potential for that, yes, and I think it would be appropriate to analyze that for the best interests of of each child, depending on the family circumstances.
All right.
Kimberly Surratt, for the record. Sorry, I've said it so many times.
Yeah.
I'm losing track.
So would it make sense then to also add some best interest factors to the statute? And I would think within 107 instead, or 127 instead of 125C, where we're giving guidance to the court to establish what those best interest factors should be.
Kimberly Surratt, for the record, Chair Scheibel. I would agree that there's additional work to be done throughout all of the family law chapters to continue to assist all of our LGBT families to have success in their family and their parenting. I have done that incrementally over the years with lots of different bills to gender neutralize, to, all that type of stuff. There's more work to be done, absolutely.
All right.
Good work to be done.
But specifically as to, my concern is just, as I've said before, we're dealing with areas where when we don't give guidance to the court, the Supreme Court will either make it up or not opine on the issue because we haven't delivered that kind of guidance. Would it make sense? Are you amenable to, in the process of working this bill out in its final form, to provide the guidance to the court so we can establish some factors that the court, and they of course won't be all inclusive, but some factors to give guidance to the court in how to assess what is in the child's best interest, particularly since now we've got multiple parents that are all vying for time with the child.
And Rochelle Wynn, for the record, it is something that, like I said, it is an ongoing conversation. I know that you've had pretty detailed, long conversations with Ms. Surratt this weekend regarding, potential changes. I know there are some things that we are incorporating that you had brought up in the thing. I think it is something. I know that we have been working with LCB staff to make sure that there aren't any concerns. I think that we've made a very clear, legislative history in all of these hearings to, incorporate some of the concerns that you have. But I think I'm obviously open to having any kind of conversations on your thoughts on the matter. But I do believe the bill as we have it stands with some limited changes that we had mentioned that would be forthcoming in any potential work session that we would have, kind of incorporate some of those concerns that we have.
All right, thank you so much. I understand we have a question from Senator Orenshaw as well. Go ahead.
Thank you very much, Chair, and Assemblyman Wynn and Ms. Rath, thank you for bringing the bill. And while I practice in a family courthouse, I don't consider myself a family attorney. I practice in juvenile court, and one thing I like about the bill is that in juvenile court so often I see a real vacuum as to placements for children, and I feel like a bill like this could lead to more possible placements, for children, and that would, be someone who loves them and wants them there and wants to nurture them. And very often in juvenile court, we'll see agencies and our social workers looking for fictive kin to see if we can place a child there because we don't have enough options because folks on the birth certificates may be unable to care for the child, may be deceased, may be incarcerated, and on, and there may not be options. So I really like the bill, and I like the possible really good consequences for children facing juvenile court and giving more options for placement. One question I have as to the language on page 3, section 5.2, the proposed new language at section lines 9 through 11. It says each prospective adopting adult and each legal parent seeking to retain his or her parental rights must be joined as a petitioner. I like that language about the joinder of the current legal parents, and I'm just wondering, what do you see as the what would be weighed in terms of whether the legal parent is seeking to retain his or her parental rights? Would they need to be actively involved in the court process, or how do you feel that will be defined if this passes into law, that new language? I like that new language. I'm just wondering how you think that would be interpreted.
Thank you, Madam Chair. Kimberly Surratt, for the record, to you, Senator Orenshaw. The joined as a petitioner is the key language at the very end of that sentence, that I want them to be a party in the case. We use the word, again, petitioner for adoption petitions. And so, it's kind of a slurred word there between party and petitioner. But it's interesting because this conversation has come up many a times amongst step-parent adoptions in the past, where I've had a lot of practitioners call me and ask, do I make the current parent a petitioner in the action? And I say, well, by practice, that's what we do when we're in front of the court. But the chapter was silent on that all along, whether or not you were supposed to do that or not. I've always said it was good practice to. So I'm hoping this actually is the first time we actually have it written down. It says, you make them a party.
Thank you. Thank you for the clarification. I appreciate the language. Thank you, Chair.
Thank you. And next, we'll go to Majority Leader Canizaro.
Thank you, Chair Scheibel. And I wanted to thank you, Ms. Surratt and Assemblywoman Nguyen, for bringing the bill. I obviously am very supportive of this. I think I appreciated, Assemblywoman, you highlighting that when we're talking about an action under this particular bill, we're still dealing with a court system. We're still dealing with a court structure that requires the court to make a determination. The court still has to weigh all of those things, and they would still be considering the best interests of the child, which is, I think, a very common thing for anyone who has practiced in this area of law to understand and to be able to articulate that. And of course, that's going to be different for every case. For me, I think one of the nice parts about this is that it does so much to allow us to recognize that there may be more than just a mom and a dad who care very much for a child. And when we're putting that in the context of parental rights, there are a lot of parents whose parental rights mean nothing for the support of that child because they're either unable or unwilling to care for that child, to support that child, to be there in that child's life, and lots of people who are willing to step up and do that. And the fact that we are looking to confer legal rights on those people, I think, does nothing except to help that child understand that there are people in this world who love them very much, even if the people who were supposed to have those parental rights don't. So I am very supportive of this bill. I think it makes a lot of sense. And I guess I just wanted to, this is probably more of a comment than an actual question for either of you. But I think when we talk about if it's a mom and a dad and they're married, that somehow that's not going to be messy for anybody who's been in the middle of any kind of divorce case or knows people who have or are children of divorce. That is very much not the case in a lot of situations. And sometimes where there are multiple people involved who all really care about that child, it doesn't have to be messy. Maybe it is anyway, but at least we're putting some legal constructs around ensuring that a child has someone who is there to care for them, not only in their day-to-day lives, but from a legal sense. And I just really think that that's why this is such an important piece of legislation. And I know you're still working on some language for amendments, but I think this goes a long way in allowing us to set up a system that really does benefit the child in the end.
Thank you, and that was our intent. I know that when the concept and the need for it was brought up by Silver State Equality, Rochelle Wynn for the record, it immediately resonated with me, with friends that have been in this situation, but I think it's something that potentially affects everyone. It's in everything, like it's a family situation. Our families are complex. Families are messy. Divorces are messy. Adoptions are messy. And it doesn't mean that those children shouldn't be have the love of parents that are parents in every sense of the, circumstance. There are situations where you have siblings that are taking care of their nieces and nephews, and they are every part the parent in those situations. And if they want that legal recognition and the consenting of parents want that as well, I think we should allow for a child to receive as much love and as much attention, not only in their hearts, but also under the law. And I think this bill is a step in that right direction. So I appreciate your support. And if there are any other questions, we'll be happy to answer those.
Thank you so much. And I will take a point of privilege here and express my appreciation to everybody for presenting this bill. And I'm a co-sponsor of the bill because I think this is an incredibly important part of making the law to reflect the community that we live in and ensuring that people who love and care for children who are their own, because that's what a child becomes when you adopt them. They become your own. And I think that it's important that they have that legal recognition. And I think that, we've heard multiple stories, both in the Assembly and here in the Senate, that demonstrate that this need exists. It's not hypothetical. It's not theoretical, but we've seen real families who would actually benefit from having the ability to recognize an additional parent. And so if we can do that for families going forward and prevent some kids and some parents some heartache, then it's well worth our while. So with that, I thank you again for your presentations. We will move to testimony. Is there anybody present in the room to give testimony in support of AB 115? I'm not seeing anybody, so we'll go straight to the phones, please, Mr. Kyle.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 115, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 115, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
All right, thank you. We will now open up for testimony in opposition to AB 115. Is there anybody present wishing to give testimony? I don't see anybody, so we will go straight to the phones. Mr. Kyle, on opposition testimony in AB 115.
Thank you, Chair. To testify in opposition on Assembly Bill 115, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 115, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 695. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Chair. This is Holly Wellborn, HOLLYWELBORN, with the ACLU of Nevada. Once again, I did not push star 9 quick enough in the support when we were getting testimony for support, and I apologize for that. And I will continue to work on that. But if it is okay with you, I will just quickly register our support for this incredible piece of legislation and keep it at that. Thank you, Madam Chair.
Thank you, Ms. Wellborn. We'll let the record reflect that the ACLU of Nevada is in support of the bill. And with that, is there anybody else in the queue to give opposition testimony?
Thank you, Chair. Once again, we are currently on opposition testimony on Assembly Bill 115. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 321. Please press star 6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Yes, my name is Julie Hammer, JULIEHAMMER. I actually am in opposition to this, and one of the things that needs to be made painfully clear in this legislation, I'm not clear whether you're trying to amend parentage rights under Nevada Revised Statutes 126 or whether you're trying to amend Chapter 127. I think it would be a critical requirement that if you are pushing forward 3, 4, 5, 6 parent adoptions, that the biological and natural legal married parents be required to terminate their rights first under Chapter 432B and then come on a united front with 5 or 6 parents under Chapter NRS 127. My family has been subjected to unauthorized intrusion Currently, we have not seen our eldest daughter in years because the babysitter moved for parental rights of our child without our daughter being joined to the action, without the father being joined to the action. There was no hearing held. The court unilaterally decided there would be no hearing. The court literally awarded this married woman and her husband rights under Chapter 126 against my fit parents' wishes. So if any of this legislation needs to be put into place, I mean, my husband and I are married. We have 2 children. We have not seen our daughter in years. She has called the police and wanting and fighting to come home. She was taken from us at 6.5 years old. So if this legislation, in its current format, in my opinion, is filled with so many holes and so many room for error and misinterpretation, and when you talk about giving guidance to the judges, it needs to be crystal clear so that there is no room for interpretation, so that fit parents' rights are violated. And now I understand when you're saying, when you're coming together on a united front, that means written authorization, notarized authorization, presented to the court by the litigants, not by their attorneys, not by some other representative, but by the litigants themselves, to prevent any misinterpretation or people alleging that other parties were served when they were never served. So that would be my biggest opposition, is that this legislation in its current written format is filled with so many errors that could create disaster, such as been created in my family for 8 years.
Thank you, caller. And as a reminder, we are currently on opposition testimony for Assembly Bill 115. If you've recently joined us and would like to provide opposition testimony at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 223. Please press *6 to unmute yourself. And slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
My name is Emily Mimnah, Mimanaughh, and I'm an attorney in Nevada testifying on behalf of the Pacific Justice Institute Center for Public Policy in Opposition. Simply put, this bill is bad for Nevada. Supporters have highlighted the need to protect step-parent rights and LGBTQ rights. However, current law already allows such persons to adopt with full parental rights. What this bill does, however, is allow any number of adults to adopt a minor child. Now, in the scenario where 3 adults have a pre-existing parent-child relationship, such as a step-parent, courts can be empowered to recognize that relationship without revising the entirety of Nevada adoption law. Likewise, concerns about birth certificates, allowing them to recognize both deceased and current adopted parents, can be revised without this bill's sweeping proposals. What is not necessary and not explained is why courts should contemplate allowing 4 or 5 or more adults to adopt a minor child. The question is, why is there simply no limit to the number of adults that can adopt a minor child? This is not simply recognizing the importance of extended family. That's already addressed by existing law that empowers parents to legally appoint, for example, the adults who's to care for their child should they become incapacitated or deceased. This bill is unnecessary, and it's a radical rewrite of public policy. Supporters point to California, one of only 2 states with even remotely similar legislation, but that law, SB 274, only applies in the context of a pre-existing relationship. It does not allow multiple adults to simply petition for the adoption of a minor child. This is also practically unworkable. While a group of adults may be united and agree at the time of adoption, there's no mechanism to address subsequent divisions, disputes, or divorces across these groups of adults who will have equal and competing legal rights, leaving courts to resolve messy things such as custody, visitation, child support, potentially across state lines. This does not help family stability and is not in the best interest of a child. Finally, the bill gives no reason why it deletes references to a mother or to a father. Erasing these terms, mother and father, is wholly unrelated to the stated intent of this bill. For these and other reasons, we urge you not to pass
AB 115.
Thank you, caller. Caller with the last three digits, 718. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Nakia Bonds, NAKIA BAHNS. I think that this proposed legislation is very irresponsible. To give this court system that already has so much abuse of discretion in the way they rule and what they do is a disaster. I have been a victim of this family court, and this legislation would it would be awful. I have not seen my 8-year-old son in almost 2 years. I have no idea where he is because of a judge who used discretion to do whatever she wanted. And this was with a man who had never been involved with my son. There was never paternity testing. He walked in to court and he walked out with my child. No reason as to why. The best interest factors are a joke. So when there's already an ongoing problem with so many families that continue daily to be destroyed because judges get to use their discretion, this is demonic. It's not okay. That the court is so unclear on a lot of things. So to propose something like this without there being specifics and things being outlined to where there could be no other interpretation is a disaster. And my son, he's 8, he's going to be 9. As I said, he has 3 siblings. They have not seen him. His grandparents have not seen him. We don't know where he is. Nothing because of what a judge did, because she used her discretion. And she did it because I was a black woman and the other man was white. So these kind of things cannot, just have so much room for error. And it does. It has a lot of room for error. So I oppose.
Thank you, caller. And if you've recently joined us, we are currently on opposition testimony for Assembly Bill 115. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 585. Please press star 6 to unmute yourself. And slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, my name is Ludmila Piankovska, Lyuda Pyankovska. I'm opposing this bill. I believe this Assembly bill failed to present a compelling state interest in creation of such severe intrusion over fundamental liberty interests of fit parents. I believe there is no authority to grant parenting rights to a third party when a suitable natural parent have a custody. I believe custodial parents have a common law to veto power over visitation between the child and all other third parties except for non-custodial parents. And it looks like this bill comes with pretense. It's all about when united petition comes into place. However, this bill completely disregards the consequences when there is dispute comes into place. I believe existing laws, when it comes to third parties seeking for court-appointed visitation or child custody with the kid, the third parties must overcome presumption by clear convincing evidence at evidentiary hearing when parents oppose those petitions. We have NRS 125C050 petition for rights visitation for relatives and other persons. We have NRS 125C004, award of custody to a person other than parent. We have NRS 159061, guardianship over minor kids that says the parents must be first considered. It looks like the people who create this bill, they are facing difficulties to overcome those presumptions. So they found a way, let's just create this united fund
and we will pretend everybody's peaceful here. But the problem here with this bill is completely does not even create awareness of what happens when there is dispute. This bill is disaster. I believe Truxell versus Truxell case in the United States.
That's 2 minutes, so you're going to have to wrap up, please. Thank you.
I believe that U.S. Supreme Court prohibits state intrusion into parenting authority, and this bill violates that.
Thank you, caller. As a reminder, we are currently on opposition testimony for Assembly Bill 115. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 535. Please press star 6 to unmute yourself. And slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Tiffany Wagner, last name Wagner. I'm 100% in opposition to this bill. I think it's disastrous. Nobody's talking about the impracticality of the ability to give parenting rights to unlimited amount of people. How do you divide a child 4, 5, 6, 7 unlimited ways? How do you divide a child's time like that? It is inarguably not in the child's best interest to have this kind of legislation passed. There's already legislation for guardianship, and there's already legislation for adoption. And as was stated before, there's too many hurdles to overcome. Family court is completely muddled already as is. The judges already have basically a practically unlimited amount of discretionary power as is. I don't think that they need to be granted more. The biological parents should absolutely have to have their rights justifiably terminated first before giving rights to any other party. That is my stance. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give opposition testimony at this time.
Thank you. We will move then to testimony in the neutral position on AB 115. Is there anybody present in the audience? Nobody here to give testimony, so we'll go straight to the phones. Thank you.
Thank you, Chair. To testify in neutral on Assembly Bill 115, please press star 9 now to take your place in the queue. Once again, to testify in the neutral standing on Assembly Bill 115, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 857. Please press star 6 to unmute yourself. And slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello?
Yes, caller,
Hello?
please proceed. Yes, please proceed with your testimony.
Yes, my name is Mr. Hall, Hall. And I am anything but neutral. I'm sorry I couldn't get onto the line for some technical issues. Here's the issue that we have with this bill, AB 115. We have a family court system that is completely, astonishingly off the chain crazy. And when I say crazy, I mean like genuine insanity. First of all, we have, like in my particular case, I'm involved in a case in the family court, which is now heading to the Supreme Court. And my ex-wife was responsible for the death of our 2-year-old son. Her new current husband has over 20 felony counts, including child endangerment, including shooting live weapons inside of the house, including he's responsible for the death of 3 of his children. Now, I don't see any way possible to give any more discretion to a court that is just unhinged. And not only that, but there's something else I'd like to say. There's the person that proposed this bill that's sitting there across the desk in the black. Here's the problem I have with her. She's been responsible. and in a
Okay,
position
we are going
deal
to
with
move
some
on
of
to
these
the next
family court
caller
issues
now,
and has not
please.
done that.
Thank you, Chair Scheibel. With that, there are no more callers at this time.
Thank you. Do the presenters, that concludes testimony on AB 115. And do the presenters have any brief comments in closing? Go ahead.
I will-
Assemblywoman Wynn.
Rochelle Wynn for the record. I will be very brief. Thank you for your consideration of Assembly Bill 115. Just to point out a couple of things. Obviously, it sounds like there are lots of concerns that some of the callers in opposition had with our family court system. I will say that this law mandates and requires consent of the parents. So this would never be a situation where you had two parents and they got a divorce and there was another parent that wanted to adopt that child. Both of those two original parents would have to first consent to that adoption of that third parent. And then, in addition to that, the judge would have to also consent to the further levels of consent. So this is a situation where there has to be consent before it even goes to the judge for that determination. So I want to make that very clear in this. This is not a situation where a new step parent can come in and take the custody rights away from like another child or unadopt a child from two existing parents. You would have to have that consent of those parents. I think it's very clear in the language of this. And then in addition to that, we have some judicial protections that they would also have to review this to see if the consent was appropriate as well. So I know that there were some comments in opposition, and I think that it is misguided. If you look at the language, the plain language of the bill, again, there has to be that consent, and that is what this addresses. So with that, I would thank you for your support of Assembly Bill 115, and I look forward to any changes that we might have in a potential work session in the future.
Thank you so much, Assemblywoman Wynn, Ms. Surratt, Mr. Wade, Senator Harris. Thank you all for your presentation and for answering our questions today. This concludes the hearing on AB 115. I will now close the hearing on AB 115. I will now open the hearing on AB 296. I understand we have Ms. Korbulik here in person. It's a pleasure to see you. And please go ahead whenever you're ready.
Thank you. Rochelle Wynn for the record. Thank you, Chair Scheibel, as well as the members of the Senate Judiciary Committee. I'm here to present Assembly Bill 296. This establishes penalties for those who engage in doxing. This bill does not create criminal penalties. It just creates a civil cause of remedy. Just for everyone's edification, doxing is a form of online harassment that has been gaining popularity. Doxing is the posting of private or identifying information about an individual, group, or organization with the intent that that information be used against the target for an unlawful purpose. These actions are a severe threat to our community, particularly individuals of protected classes, affecting the ability of already marginalized communities to be safe both in digital and physical spaces. Doxing should be codified into Nevada state law so we can protect targets and hold perpetrators accountable for their malicious and reckless actions. There's no question that doxing can be extremely serious and harmful, particularly when the offender intends for the disclosure of that information, that personal information, to result in the death, injury, or stalking, and must be accordingly taken seriously under Nevada law. The issue of doxing became real to me about a year ago when I had the privilege to meet Tanya Gersh. And for people that are not familiar with her story, and by example only, there was a publisher of a neo-Nazi website called the Daily Stormer, and one of its organizers in 2017 he was one of the organizers of the 2017 white supremacist rally in Charlottesville. At the time, he posted the name and address of a Jewish real estate agent in Montana, posted photos of her children, and had all of his followers, which were thousands, also on his website respond, and his purpose and intent was to stalk and terrorize this poor soccer mom. His followers understood that all too well and responded with hundreds of threatening calls, anti-Semitic messages, posts on Facebook, posts on social medias, posts on things like Yelp. Her family was subject to swatting. Her parents were in fear. She was worried about her children and their safety when they walked out of her house. In this case, this bill would distinguish and not only capture conduct that simply involves identifying people online with the purpose that they may be protecting others or tracking down extremists or reporting on a public interest story. Unlawful doxing is different from the work of advocates, researchers, and the press, including those at the Anti-Defamation League, who are doing this to identify extremists and help with law enforcement agencies to investigate these for possible crimes. These activists and researchers are operating are not operating unlawfully, maliciously, or recklessly with a reckless state of mind. The same goes for journalists who break important stories, people who take on powerful institutions in the interest by disclosing information, for example, about political donations and things like that. And people who report abuses of power or otherwise act as whistleblowers. This law does not apply to those individuals. To the extent that the people are publishing information to share facts and not acting with this level intent to harass individuals with a reckless regard for others to carry out criminal conduct such as death, injury, or stalking, anti-doxing laws should not apply. When it comes to online harassment, it is a fine line to walk, and so it's important that when we are enacting anti-doxing legislation, that we keep that in mind. I know that I've been fortunate enough to work with the Anti-Defamation League, and I believe we have Ms. Jolie Brislin, and I'm not sure who else is on the line right now, to be able to also speak to this issue and answer any questions regarding the bill, but I also do have the testimony here today of Heather Korbelik, because I know that she also has, like I said, her own personal story that this type of legislation would prevent others from having the same kind of experience that she had. So if we can first go to Ms. Korbelik, that would be great.
You're doing great. Korbulik.
Korbulik. Oh, I knew it.
Good afternoon, Madam Chair and members of the committee. My name is Heather Korbulik, and I'm here today to provide personal testimony on Assembly Bill 296, and I appreciate Assemblywoman Nguyen for bringing this forward. As many of you know, in April of 2020, Governor Sisolak asked me to step into the role of the interim director for the Department of Employment, Training, and Rehabilitation, commonly known as DETR. A month beforehand, the governor had made an incredibly difficult decision and drastic decision to shut down the government, or to shut down the state of Nevada in the best interest of public health. And DETR was receiving an unprecedented number of unemployment claims as a result. With the highest rate of unemployment ever recorded in the country's history, hundreds of thousands of Nevadans found themselves filing unemployment insurance claims on a system that was never intended to scale at such a rapid pace. Nevadans were desperate to reach someone at the department to get answers to their questions and resolve issues on their unemployment claims. DETR was staffed at a level that would accommodated the state's best economy, and literally overnight, the state experienced its worst economic landscape in recorded history. Tens of thousands of Nevadans were justifiably frustrated and scared. Adding to the significant challenges that DETR was facing, Congress had just introduced a new unemployment program to support the hundreds of thousands of newly unemployed Nevadans who lost their gig employment and would not be eligible for standard unemployment insurance. Launching the Pandemic Unemployment Assistance Program, otherwise known as PUA, was an enormous undertaking in and of itself. I knew that I'd be walking into a critically important response effort, and I knew that Nevadans were upset and they needed answers. Because I have led agencies through challenging times before, I knew that I had to make important decisions quickly. I needed to be transparent about our efforts, and I needed to constantly communicate with the public. I did my best to learn fast and move fast. I'm sorry. I apologize. I haven't had a chance to talk about this publicly. I did my best to learn and move fast, and I'm really proud of what was achieved during my short tenure, and even more proud of Dieter's continued response since. Thousands of Nevadans reached out directly to me while I served as the director, and all of them had equally compelling stories of desperation and fear. Every day my heart was heavy, and I felt an overwhelming responsibility to help. A small percentage of these people targeted their anger directly at me, calling me names and slandering my reputation. An even smaller percentage of those people chose to harass and threaten me with, at the very least, the intent to scare me. Those people posted my home address and my personal phone number online with an intent to encourage and promote others to join in their harassment. They targeted me on every social media platform and every other online mechanism available to them. Some of them questioned whether I should be alive any longer. I don't remember all of the threats, thankfully, but I remember exactly how they made me feel, and it was terrifying. There are two incidents that I just want to tell you quickly about that really stand out. The first legitimate threat to my safety came during a time when my husband and children were out of town. At the time, we didn't have a security system, but we do now. A law enforcement officer spent the night parked in front of my home, and I came home that night after an exhausting day, and my neighbors walked out to ask what was happening and why was there an officer parked in front of my home. I told them about the threat, and I asked that they be on the lookout for suspicious activity. They were all loving and supportive, but they were also very afraid for their own safety. I went inside and I called my husband, and I sobbed, and I told him I was done and that I couldn't live like this. He told me that I was stronger than the people who were threatening me, and that he would cut short his trip and come home and install a security system. I am really grateful for his belief in me and his support. My family returned, and my children, who were used to playing in the front yard by themselves, were forbidden from leaving the house without supervision. I was so scared that someone would take them or that would hurt them. They saw my fear, and it confused them, and it scared them, and they were angry with me. I kept my chin up, and I worked as hard as I possibly could, and I tried to forget. And then one day, a few weeks later, in the middle of a meeting with lawmakers, someone posted my personal cell phone number on Facebook, on a Facebook page, and within minutes I had over 100 calls, and my voicemail was immediately full of hateful messages. I tried to use my phone to call Verizon to change my phone number, but I couldn't even dial out because the calls kept coming in so fast. I sat down and I wept at my desk, and I decided that I could no longer tolerate putting my family in this position. And I would not live in fear for simply trying to do my job. During this time, my close friends and family who knew what was happening sent me articles from across the country with stories of public health officials and others who were experiencing similar threats and harassment. It made me sick to read about the terrifying experiences of these dedicated civil servants who simply wanted to protect people. I'm here today doing something I didn't want to do because I really believe in what Assemblywoman Nguyen is putting forward in Assembly Bill 296. No one, under any circumstance, should be made to feel the way that my family and I felt when people were using my personally identifiable information to threaten and harass me. Thank you.
Thank you, Heather, for sharing your story. Rochelle Wynn for the record. I believe that we can go to.
We'll just take a brief pause to thank Ms. Korbulik for having the courage to be here today and to share with us. And it is unfathomable what you have gone through, and I'm truly sorry. And I think the majority leader would also like to make a few remarks.
And to me, the fact that you are here, I think, speaks truth and life into the words from your husband, that you are stronger than any of the threats. The incredible work that you have done for the state of Nevada, we should all be so thankful for. To not only stand up and to lead us in developing the exchange program here in the state, which is helping tons of Nevadans have access to health care, the amazing work that you have done to lead us through that process and to make sure that that is a system that is providing help to Nevadans. That even over and above that, when asked and called to do one of the most impossible tasks that I think anyone in public service could be asked to do, in a position and on a platform that could not have dealt with the magnitude of what the COVID pandemic has put and thrust upon it. And the fact that you said yes in the first place, I think speaks absolutely to your strength and to your capabilities. And frankly, I know when I heard that you were coming on to do that, I thought, well, oh my goodness, they found one of the best people that they could possibly have put in this position. And if there is a way out, Ms. Korbulik will be the person who helps us find that. I believe that very much, and thought that immediately when that was announced, and thought that was the most brilliant decision that could have been made, because if there was a way out, you were going to be the person who could do that. The fact that we have someone like you here in the state of Nevada, I think, is remarkable. I know I am personally grateful, and I think there are so many Nevadans who are so grateful, even if they don't know that you are the person that they should be grateful to. The fact that you are still continuing that work, that you are now also working hand in hand to make sure that we can do the business of the legislature here. I can't thank you enough. I know it is hard to share these kinds of stories, and I can't imagine how terrifying this whole ordeal has been. But know that there are lots of people here in the state who appreciate very much the work that you have done, that you are doing, and that I think you've demonstrated to all of us, certainly today, if not before. Certainly before for me, but definitely today, that you are so much stronger than anything that people can throw at you. And that doesn't mean that we shouldn't also take action to make sure that doesn't happen to someone else. And sharing your story, I think, helps to lead the pathway to that. But the amazing things that you have done for the state of Nevada, we should all be so lucky to have even just one of you here in the state. So thank you very much for being here and for sharing.
Thank you. Assemblywoman Wynn, are there other presenters on this bill who you'd like to
I think
turn
just
to?
briefly, we have Jolie Brislin with the Anti-Defamation League. I don't know if she's on, and I see Beth on there as well. I don't know if they have anything they'd like to say or just available for any questions.
Go ahead whenever you're ready, Ms. Breslin, or anybody else.
For the record, my name is Jolie Brislin, and I serve as a regional director of the Anti-Defamation League Nevada Regional Office. Before I get started, I just want to thank Heather so much for sharing her story and having so much courage. Because of her testimony today, I hope to prevent this from happening to other people. On behalf of ADL, I appreciate the opportunity to speak with you this afternoon in regards to AB 296. Thank you for convening today, and thank you to Assemblywoman Wynn for your sponsorship of this bill. Founded in 1913, ADL has a timeless mission: to stop the defamation of the Jewish people and to secure justice and fair treatment for all. Today, more than ever, this mission's relevance endures. At ADL, we work to combat anti-Semitism, prejudice, and hate of all kinds while defending our democratic ideals and civil rights. Unfortunately, we know that hate and extremism are on a rise, and digital spaces are not immune. The disparities are stark in terms of which communities are particularly impacted by hate. According to a recent national study that ADL released, 27% of Americans experience severe online hate and harassment, defined as including sexual harassment, stalking, physical threats, swatting, doxing, and sustained harassment. Additionally, in this 2021 report, 33% of respondents attributed at least some of the online harassment they experienced to their identity, defined as their sexual orientation, religion, race, or ethnicity, gender identity, or disability. Generally, 28% of respondents reported having experienced race-based harassment. African American respondents specifically reported a sharp rise in race-based harassment, from 42% last year to 59% this year. Additionally, more than 1 in 5 Americans reported experiencing harassment based on their religion, with 57% of Muslims and 31% of Jewish respondents reporting harassment because of their religious identity. We must do more to ensure we are protecting against online hate and harassment and its consequences to individuals' personal and professional lives. Such actions include the emerging threat of doxing. ADL urges this committee to support AB 296 to address doxing in Nevada state law. If passed, this law would prohibit a person from posting another person's information online with the intent to harm them with a reckless disregard of causing death, bodily injury, stalking, or mental anguish. According to ADL's 2021 report, 81% of Americans agree that laws should be strengthened to hold perpetrators of online hate accountable for their conduct. This bill empowers victims and targets of this digitally enabled hate to seek recourse. Thank you for your time and your consideration, and look forward to any questions you may have.
Thank you, Ms. Brislin, and we're ready for any questions that you might have.
All right, do members of the committee have any questions? I see Senator Pickard, go ahead.
Thank you, Madam Chair. And Ms. Korbulik, I agree that, it's sad, it's frightening when we have public officials that are targeted for doing their job. And I join with everyone else in applauding you. We all, I think, thought that you would do a fantastic job coming in. Your reputation preceded you. We thought, we had a chance of getting this fixed, and then we saw what happened. And Assemblywoman Nguyen, I'm glad to see this kind of attention. I'm just a little concerned with it's section 1 sub 3B, where public officers acting in their official capacity are excluded from application of this bill. So Ms. Korbulik's perpetrators would not be subject to the penalties in this bill, nor would law enforcement officers. And I'm wondering, we just saw what LeBron James did to the Ohio officer acting to save a life, and yet here we are once again, in my view, inviting the public to dox these law enforcement officers. So can you address that and tell me how this isn't anathema to exactly what we're trying to accomplish here?
Thank you. Rochelle Wynn for the record. That's a great question. And I will tell you that any of the doxing legislation that has been addressed, that's been proposed, including this, there is a lot of there's a lot of people concerned about the legal overreach of doxing bills. There's obviously a very, very fine line between protecting free speech on both sides, both online and offline, and rightfully raises serious and legitimate questions kind of about how it comes to codifying these laws and who it applies to and who it doesn't, especially in this free speech realm. I have Beth Holtzman. She is on the Zoom right now. She has been working tirelessly across the country in developing anti-doxing legislation, and I think she's probably in the best position to be able to address your concerns on why certain people, public officials, elected officials, law enforcement, would be specifically excluded from the provisions of this civil litigation. And so I will turn it over to her, Chair, if that is fine.
Thank you. Beth Holtzman. Beth Holtzman for the record. I serve as ADL's Western States Counsel. Thank you for having me here today. To answer the question, so that is true that it is hard because there are a lot of public officials who their information is being shared. But for this bill, we were really focused on trying to enable communities to still hold law enforcement officers and public officials accountable for their actions that are violating the law, or such as people trying to expose bad behavior in a whistleblower capacity. But we have a very high intent standard for this bill, which will prevent it from being abused in situations where the contact information is just shared casually. It really needs to be shared with the intent to cause severe harm.
Thank you, Ms. Holtzman. But what I'm suggesting is that the doxing of law enforcement, particularly, and any public officer, including Ms. Korbulik, it says right in the opening sentence, it says the provisions of this section do not apply to the dissemination of personal identifying information or sensitive information which depicts law enforcement officers acting under the color of law or a public officer acting in an official capacity. So this bill, as it's written, would not apply to the perpetrators for Ms. Korbulik's harassment, nor would it apply to the Ohio officer, or that a Nevada officer, or any other public officer acting in their official capacity. I'm not talking about those that are committing illegal acts like Derek Chauvin, but even then, to release private information, the personal identifying information that could lead those that would harass directly to their doorstep. Why isn't that illegal for any recipient, for any person who's trying to do their job in an official capacity? This does not apply to them. How is that even remotely appropriate?
I'll go ahead and try to answer it first, and then I can have Ms. Holtzman follow up with some of the more intricate legal arguments. But I can Rochelle Wynn for the record. I can tell you that we are doing baby steps to get to the legislation and make sure that it is crafted appropriately, that it protects free speech. As an elected official, as you know, our addresses are public knowledge, are public record. We are in a very different situation. You have to have your address listed because you have to live within the district that you are running for office for. So there are certain things that, as an elected official, you are in a very different situation. So to distinguish just in that group, I think you are in a very different scenario of individuals. And I think that you can be held and you should be held accountable for your decisions, your statements, and your actions as a public official. And especially an elected official. As far as law enforcement, what our intent is to not prohibit it and make the language so difficult that, for example, with the insurrection in Washington, D.C., you want to be able to help law enforcement be able to capture and identify some of the individuals that were involved in the death of the police officer, the beatings that took place against security officers, the vandalism, any of that kind of stuff. And we were able to do that by publishing photographs and information and trying to identify those individuals that committed those particular crimes. We've seen all too often that members of the press, individuals that are out on the street, if had not been for their recordings of police officers, unfortunately, sometimes those acting in bad faith or acting criminally or recklessly, we would not be able to find that information. So I think it's a very important balance that we find that enables free speech and for members in these important areas of public interest to be held accountable. So, that was our intent. And I think Ms. Holtzman might have some additional information on, when it rises to the level where you're inciting that violence or threats of violence and stalking. So if I can turn it over to you, Ms. Holtzman.
Thank you, Beth Holtzman, for the record. I would just add that the intent of this bill, the target that we're really focusing on is individuals such as Tanya Gersh, who was not a public figure that Assemblymember Nguyen mentioned earlier. She was just a real estate agent who suffered unlawful doxing and was being harassed and stalked by several people, her family and children threatened repeatedly. And that's the target. And this kind of also just to reiterate what Assemblymember Nguyen said, we're going in baby steps. So although this bill right now has the exemption for public officers and law enforcement officers, perhaps if there's a gap that we could try to fill in the future. But right now we're focusing on the individuals who are not the public figures that don't need to be held accountable, but really are helpless in these situations.
All right, I appreciate that. I guess I misunderstood the intent, because when Ms. Korbulik came up and talked about her story, I thought it applied to the bill. And obviously it doesn't. We're going after the private individual. I don't think then that if this is narrowly targeted to avoid doxing of private individuals, then the public individuals I don't think a police officer signed up for what I signed up for. When they joined the police force, they didn't sign up for being, their families being targeted for the acts of themselves. Publishing their information, I don't believe is any more appropriate. But we don't need sub B at all if that's the case. But anyway, I'm not going to. Thank you.
I'd like to see if I can maybe shed some light on the subsection B of subsection 3, which is on page 3. And the way that I'm reading it, it says that this does not apply to the dissemination of information which depicts a law enforcement officer acting under the color of law or a public officer acting in an official capacity. So stop me if I'm wrong and explain why, but it sounds to me like this is allowing for individuals to produce and publish things like pictures, videos, screenshots of something that a public officer did in their official capacity, standing in front of a room of, legislators, standing in front of a crowd and speaking in their official capacity, posting on their official Facebook page, any type of speech that you could screenshot and share with the public. What it doesn't say is that you can search for that public officer's personal address and publish it along with additional commentary that says you should go to so-and-so's address and harass him or her. I guess if the public official was posting their own address, you could share it. But the way that I read this is that this allows for somebody to reproduce and disseminate information that was already made available by nature of somebody being a public official. It does not empower anybody to dig up additional information, find that information through a means that would not be depicted in a normal photo, video, screenshot, email, perhaps, and it would not allow for anybody to utilize that information in a way that is intended to inspire violence towards or harassment of that person.
Thank you. Rochelle Nguyen for the record. That's correct. And I believe that there are other statutes that actually protect the personal and private information of our law enforcement officers, as well as a big laundry list, actually, of our first responders that are in there. So you are correct.
Thank you. Other questions? Go ahead, Senator Harris.
Thank you, Chair Scheibel. And I'll echo the comments of my colleagues. Ms. Korbulik, thank you for being here and sharing your story. I'm wondering a little bit about, if you guys can tell me how this isn't already an actionable suit, right? So is this not a classic intentional infliction of emotional distress, or is there some other tort that's already in place? Why do we need to create something new?
And I will let Ms. Holtzman answer that question.
Thank you, Beth Holtzman, for the record. It is possible to try to bring a case under intentional infliction of emotional distress or another tort. However, we've found in other states that it's very difficult and that state laws are not often written to contemplate the realities of online spaces and how cyber harassment, cyber stalking occurs, and doxing is the online elements of it are not always reflected in other sorts of torts. And so we find it is most helpful to enact a statute to have the proper language that really takes into consideration and focuses on this particular actions that occur online and are able to reflect that and to provide a civil cause of action for individuals who are suffering from experience unlawful doxing.
And I will tell you, Rochelle Wynn for the record. I know that it was our intent to look at this because a lot of the emerging technologies that people are using to harass and target and this hate is online. And, unlike someone coming and yelling at something to you in person, like this online hate survives indefinitely, and it is repeated, and it is traumatic, and it is traumatic over and over and over again for these victims who have to go on. I heard when I spoke with Tanya Gersh, she had talked about how people told her, just get off Facebook, just get off of, Twitter, just get off of all the social media. It's so tied in with how we communicate. It is so tied in with how we govern. It is so tied in with how we meet and communicate with our families, with our communities, with our business interests, that it is unrealistic to do that. And I think our laws need to reflect this new online, space that unfortunately has been exploited to target hate and violence.
And Chair, if I just may with a quick follow-up, I don't know if we've taken the time to update our harassment laws to sufficiently capture the types of ways you can be harassed online. Releasing your personal information obviously is not the only way people are harassed online. And so I know it's a little late in the session, but if that's a topic that we need to pick up and make sure that harassment covers the type of ways that people are acting nowadays, we should try and fix that too. Thanks.
Thank you, Senator Harris. And Senator Orenshaw.
Thank you very much, Chair Scheibel and Assemblywoman Wynn. Thank you for bringing the bill, and Director Korbulik, thank you for sharing what happened to you, and thank you for leading the department during, I think, an unprecedented time that no one could have imagined. And it's terrible that you and your family had to go through this kind of harassment and threats when you were just trying to make a system that I think was designed in the 50s and 60s work with just an unprecedented pandemic. My question, I think, is for Ms. Holtzman. In states that have adopted laws like this, have there been many successful suits brought? What kind of damages have the victims been able to receive from the courts? And have any states enacted any enhanced damages, treble damages, for people who try to distribute this kind of personal identifying information in an attack on someone?
Beth Holtzman for the record. Thank you for that question. So the states that have passed this, it's been in the last year, so we haven't really seen it in action quite yet. However, other states, in addition to damages, they have done criminal penalties for unlawful doxing. And so that's been more of what we've seen is states that have the unlawful or the criminal penalties. But this is something that I can look into and follow up if there's additional information. But to the best of my knowledge, these laws have been passed so recently that we haven't had a chance yet to see them exactly being litigated.
Okay, thank you, Ms. Holtzman. Thank you, Chair.
All right. I believe that concludes our questions from the committee. Again, we appreciate everybody being here to present. We will now move to testimony in support of AB 296. There is somebody here in the room to give testimony. So we will call on you first, and you will have 2 minutes just like everybody else.
Good afternoon, Chair Scheibel, members of the committee. For the record, my name is Serena Evans, and I'm the policy specialist with the Nevada Coalition to End Domestic and Sexual Violence, here today in support of AB 296. We know that stalking, harassment takes place in so many different forms, and now in these online spaces, it really creates this new level of harassment. And I want to share a really horrific story that kind of gets shared in the advocacy community of, a jealous ex-boyfriend. They break up and he shares the girlfriend's personal information online with an address, what time she'll be home, where she lives, how to break in, and kind of paints this picture to his followers that she wants to live out a rape fantasy and to break into her house at this time to rape her because she wants to experience stranger rape. And so while this act may not come through, it also creates this level of harassment online where these people may be following, stalking, sending really vulgar messages to an individual online and creating a really heightened sense of fear. So we're in full support of this, and we thank the Assemblywoman, Anti-Defamation League for bringing this forward. So thank you very much.
Thank you, Ms. Evans. Anybody else in person to give support testimony on AB 296? Not seeing anybody, so we will go to the phones, please. Mr. Kyle.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 296, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 296, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 104, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, and greetings to the chair, members of the committee. My name is Maria Teresa Lieberman Barraga, MARIA-TERESA LIEBERMANN-PARRAGA, and I'm here representing Battleborn Progress, and we're in full support of AB 296, and thank Assemblywoman Wynn for bringing this forward. Because, in the digital space, our organization works on that every single day, and we have seen multiple times where folks on all sides of the aisle have been doxxed, or there have been attempts to dox, and that is something that, as we've heard today, has a serious toll on people. And there is a difference between holding people accountable and actually actively trying to hurt them by doxing them and putting out personal information for dangerous purposes. So thank you, Assemblywoman Wynn, and we hope everyone supports this bill. Thank you.
Thank you, caller. A brief reminder, we are currently on support testimony for Assembly Bill 296. If you recently joined us and would like to provide support testimony at this time, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no more callers to provide support testimony.
All right, thank you. Is there anybody present to provide opposition testimony? I don't see anybody, so we will go to the phone lines for testimony in opposition to AB 296.
Thank you, Chair. To testify in opposition on Assembly Bill 296, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 296, please press star 9 now to take your place in the queue. Caller, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair, members of the committee. My name's Chuck Callaway, Callaway, representing the Las Vegas Metropolitan Police Department. I was neutral on this bill in the Assembly, but with the amendments, I am in a position now where I need to come forward in opposition. First of all, it troubles me that the criminal penalties are being removed from this statute. I worked with the legislature several sessions ago regarding a swatting bill, which codified in statute some of the penalties used for this type of behavior. In Section 1 of the bill, it describes this behavior as with the intent to encourage, facilitate, a criminal offense likely to cause death, bodily harm, so on and so forth. This is very serious activity, which we are talking about, and while the ability to file a civil suit is good too, and I support that, we need to consider keeping the criminal penalties in. I also share the same concerns that were raised by Senator Pickard regarding the way this language is written. It says the provisions do not apply, and it lists public officer and also police officer. If the intent is to protect whistleblowers and people that are reporting unlawful activity that law enforcement officers or public officials are engaged in, there are mechanisms in place and there are protections in place currently to make those complaints. And you don't report unlawful activity by doxing someone. Again, the intent to facilitate criminal offense likely to cause death or bodily harm. That's not how you report someone engaged in criminal unlawful activity. The way this is written, you could be protesting in front of someone's home, say a legislator's home, because you believe that they have violated the Constitution of the state. You reasonably believe they have violated the law, so you are protesting in front of their home, live streaming their address, encouraging others to come there and potentially cause harm. And the way this is written, you would be exempt from the penalties. As I said, there are legitimate ways to report unlawful activity, and doxing people is not the way to do that. So I'm here in opposition. Thank you, Chair.
Thank you, caller. And a brief reminder, we are currently on opposition testimony for Assembly Bill 296. If you recently joined us and would like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 196, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chairperson Scheibel and members of the Senate Judiciary Committee. I'm Eric Spratley, S-P-R-A-T-L-E-Y for the Nevada Sheriffs and Chiefs Association, and we oppose AB 296. And it's well-intended but poorly written and leaves certain persons unprotected by the language. You know, in the testimony, you heard that no one should have to go through that anguish. And we felt that testimony, and we feel also that no one, including law enforcement people or elected people, should have to go through that anguish. Thank you, Chairperson.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide opposition testimony at this time.
Thank you. We will move to testimony in the neutral position on AB 296.
Thank you, Chair. To testify in neutral standing on Assembly Bill 296, please press star 9 now to take your place in the queue. Once again, to testify in neutral on AB 296, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 695, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel. This is Holly Wellborn, Hollywelborn, Policy Director for the ACLU of Nevada, testifying in neutral of Assembly Bill 296. I want to thank Assemblywoman Nguyen and the Anti-Defamation League for working with us on this bill. We share their commitment to protecting people from terrifying harassment and from racist and bigoted attacks. It is our position that this bill makes clear this statute cannot be used by government officials as a tool to punish innocent behavior and constitutionally protected speech. Posting information online is one of the few ways that ordinary people have of holding people in a position of power accountable. It was imperative that this bill did not capture activities that are protected by the First Amendment and are essential to our ability as citizens to expose and address racism, violence, and corruption in society and in our government institutions. So many defining moments in our nation's fight against prejudice and systemic racial injustice have been the result of a bystander picking up a camera, filming a video of an individual engaging in bigoted or violent behavior, and sharing that video and the accompanying identifying information online. Again, thank you to the sponsor. We believe this bill is in a good place, and we look forward to continuing this conversation. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide neutral testimony at this time.
Thank you, Mr. Kyle. I'm going to turn to our committee counsel, Mr. Anthony, at this point to clarify for us how this would affect and if it would affect peace officers. And specifically, I'm going to refer to NRS 289.025, which I believe currently already prohibits sharing a peace officer's home address. But if you could just elucidate for us what would and would not be allowed under this proposed law, I would appreciate it.
Thank you, Chair Scheibel. Nick Anthony for the record. Turning back to the bill at page 3, subsection 3, the exceptions that were discussed earlier, I think the paramount component there is in paragraph B, which says, which depicts a law enforcement officer or a public officer acting. So the bill as written doesn't apply, say, after hours, somebody's at home, somebody's being harassed. Yes, that would clearly be doxing under the letter of this bill. The way it's written is it's accepted, for instance, if somebody walks into this room, takes a picture of a public official, a law enforcement officer, while they're acting in their official capacity. Madam Chair, you also asked about 289.025, and that provision of law does currently prohibit the sharing of a law enforcement officer's home address or personal information that is confidential by statute under 289.025.
Thank you very much for your clarification. Assemblywoman Nguyen and your co-presenters, do you have any closing comments?
I will try to keep it brief. Rochelle Nguyen for the record. Thank you for hearing Assembly Bill 296. I will continue to reach out to work to the opposition. I will be honest, that's the first time I've heard that there's any opposition. I think that having legal clarify the intent and who would be covered by this. I know that a lot of times in this building, people say bills don't go far enough, they don't do enough, but I don't think that is a reason to throw out what could be a good first step in targeting doxing and targeting it for individuals. Like you heard, this is a pretty new concept in law, and this bill is a step in that right direction to be able to target those individuals that are working, in this. It's my understanding under the provisions of this law, a situation like Heather's and her experience would actually be covered in this. This is not talking about her job duties when she's giving a press conference or she's in her office or she's in her place of business. She doesn't have the protections of her address being protected like other first responders or law enforcement, officers do. This would directly be on her and targeting her family, her phone number, her personal information, her children, her husband. So that is the intent in this legislation. And like I said, I'd be happy to continue having this conversation with those members of the opposition. Like I said, it's the first time I'm hearing that there was some concern. I don't know if it's concerned with the language or just we always wanted to go farther. We want to do more, but I don't think that is a reason to throw out all of AB 296 because it doesn't go far enough. We sometimes need to take baby steps to figure out and make sure that we are balancing those First Amendment rights with those in protecting our community in this new online area. But thank you.
Thank you very much. And thank you again, Director Korbulik, for your powerful statement and for being here. That concludes our hearing on AB 296. I will now close the hearing on AB 296 and open the hearing on AB 214. Whenever you're ready, go ahead.
Thank you, Chair Scheibel. Members of the Senate Judiciary Committee. For the record, my name is Venetia Considine. I represent Assembly District 18 in Southeast Las Vegas and a little bit of Henderson. I'm here today to present AB 214, which revises language in the sexual assault and seduction statute. This bill originated last session with former Assembly member Connie Monk, who envisioned a larger bill. The bill that I'm presenting today is a smaller version of that bill, and it simply removes gendered language in NRS 200.366 and replaces it with inclusive language. There are 5 changes in the bill and a conceptual amendment, which I will also discuss. That conceptual amendment was emailed to all of the committee members, and it is also available on Nellis. I am also joined with Serena Evans, Policy Specialist from the Nevada Coalition to End Sexual and Domestic Violence. And my goal today is to go through the bill, explain the conceptual amendment, turn the presentation over to Ms. Evans to provide testimony, and then take some questions. I need my glasses for this part. Okay. So on AB 214, there are 5 sections or 5 changes. Section 1, subsection 1A, Section 1, subsection 1, subsection 1A, subsection 1B, and subsection 5B. In all of these changes, we have taken gendered language and changed that to gender-neutral language. The changes in these language are for 3 main reasons. 1, to recognize the spectrum of genders. 2, because we need to put in our statute and understand that men can be perpetrators and victims as well. And also to align with other chapters in NRS that have already incorporated inclusive language, for example, the Domestic Relations chapter of NRS. The conceptual amendment begins to address the larger issues that were part of Assemblymember Monk's original bill in 2019. It is all of Section 2, and it essentially creates a subcommittee to conduct an interim study concerning sexual assault and make a report. The study and the report will include an evaluation of the laws of sexual assault in our state, the laws governing sexual assault in other states and territories of the United States, and any other matter that the Advisory Commission determines is relevant to the discussion. Recommendations and input from attorneys, victims, and any other stakeholders concerning necessary statutory changes relating to sexual assault will be included, and the subcommittee shall report the results of the study and any recommendations for legislation to the full advisory committee not later than September 1st, 2022. The first section of the Assembly Bill 214 becomes effective on on October 1st, 2021, and the second section, the amended portion, becomes effective on July 1st of 2021. At this point, I'd like to turn it over to Ms. Evans.
Good afternoon, Chair, members of the committee. Again, for the record, my name is Serena Evans, and I'm the Policy Specialist for the Nevada Coalition to End Domestic and Sexual Violence. For those of you who may not be familiar with us, the NCEDSV is the statewide coalition of domestic and sexual violence service providers throughout Nevada. And the bill that sits here before you all today is a product of a lot of conversations, outreach, and collaboration over the interim. As mentioned earlier by Assemblywoman Considine, this was the works of former Assembly member Connie Monk, so we're very thankful for her for getting that ball rolling, and we're extremely grateful for Assemblywoman Considine for carrying this on. So throughout the interim, the coalition had been repeatedly contacted by programs, sexual assault advocates throughout the state, expressing interest in wanting to work on the Nevada Revised Statute definition of sexual assault, stating their concerns that they didn't feel it was inclusive or expansive enough to cover and protect all victim survivors throughout our state. So in response to the reoccurring interest that we were getting on this topic, we at the coalition convened a work group of sexual assault advocates throughout the state, and we held this loosely formed work group in July of 2020. So this work group was really not anything formal, but just kind of where I brought together advocates and I listened to what their concerns were with the current statute, and we had a conversation of what the ideal statute of sexual assault would look like for the state of Nevada. And one of the concerns among many, not among many, but among others that arose out of this work group was that the current gendered language used in NRS 200.366 is problematic and not necessarily inclusive of all victim survivors. So many clients that our wonderful advocacy organizations serve don't identify as female or male and fall onto the non-binary gender spectrum. And the current himself, herself language that is used in NRS is exclusive of these non-gender conforming survivors, and many LGBTQIA plus survivors didn't feel safe to come forward about their sexual violence victimization. Many LGBTQIA victim survivors also felt that their victimization wasn't fully valid or taken seriously with the current use of gendered language. The other part of the conversation was that there has been this traditional narrative that sexual violence perpetrators are always male and the victim survivors are traditionally always female. We know that that's just not true. So regardless of the gender or sexual orientation of the victim and or the sexual orientation of the perpetrator, people can feel safe coming forward with their sexual violence and sexual assaults. Replacing the language with themselves and gender-neutral language will allow for all survivors to feel comfortable and hopefully safe coming forward. So really what Section 1 of this bill comes down to is the power of language. Inclusive language is necessary for the safety of everyone. Super small changes, but really meaningful impact. A couple pieces of data that I just want to leave you all with is that according to the 2015 U.S. Transgender Survey, 47% of transgender people are sexually assaulted at some point in their lifetime. That's nearly half. And according to the U.S. Department of Justice, sexual assault is one of the most underreported violent crimes, with only about 1/3 of victim survivors reporting to law enforcement. So if we can make this small change to increase the likelihood of more survivors feeling comfortable enough to come forward and potentially report to law enforcement, that means we are increasing the number of perpetrators that can be held accountable. The second part of this bill in the conceptual amendment up on Nellis, Section 2, is honestly the first step in what is a larger effort to address positive changes in our sexual assault laws in Nevada. And so this proposed amendment adds the language just that the Advisory Commission on the Administration of Justice bring together all these wonderful stakeholders to collaborate on the sexual assault and consent language. So throughout our work group that we held back in November, there was, kind of a laundry list of what the ideal definition of sexual assault would look like. And over the interim, we were working with different stakeholders, but it was just, we were being rushed and we didn't have the time to commit to really be able to create a perfect definition that would work for everyone and for victim survivors. And so ourselves at the coalition, other stakeholders are committed on working on this throughout the interim to make sure that the final product that does come out comes before you guys. Hopefully next legislative session is a really good piece of legislation that stakeholders, survivors, advocates all feel comfortable bringing forward. And so the intent is to kind of look at the definition of sexual assault, not just limiting it to rape is what it currently is, looking at our consent laws, and then hopefully creating a sexual assault statute that encompasses the many different acts of sexual violence. And so with that, I'm happy to answer any questions that you all might have.
Thank you so much. And I will also warn you that it is 3:22. I know other committees start meeting at 3:30, and so I expect that some members of this committee will be slipping out, and I don't want you to take it personally. That being said, are there questions from members of this committee? Senator Pickard.
Thank you, Madam Chair. And thank you both for bringing the bill. As you probably know, I will occasionally represent these victims, and so I'm pretty passionate about this subject as well. So I want to try to get the language as tight as we can. Also, I sit on the advisory commission, though I assume that someone has spoken to the leadership there and that they can take this on. So, because we are pretty busy. Let me we'll take this in order. There are two sections particularly that I think are ambiguous or maybe mistaken. Section 1A, where we replace himself or herself with themselves. It says subjects another person to sexual penetration or forces another person to make a sexual penetration on themselves. I want to make sure that, I think we could change that language to reflect that we're not worried about the person offending against themselves, the individual against the same individual. And then I think in B, it's backwards. I think we want to say the perpetrator instead of the child, because we don't commit a sexual penetration upon a child under the age of 14 or causes a child under the age of 14 years to make a sexual penetration on the child themselves, right? It should be the perpetrator. I think that's what it was before, at least that's how I read it, that it's the perpetrator committing the penetration on a child or causing the child to do the offense against the perpetrator. Do I have that wrong?
Thank you for the question. For the record, this is Venetia Considine. Thank you for the question, Senator Pickard, and I will answer it, but I will also allow Ms. Evans to follow up. It was my understanding that the way that this was originally written was that for subsection 1A, subjects a person to sexual penetration or forces that person to make a sexual penetration on themselves.
Okay.
Same thing with subsection 1B, where it is the sexual penetration upon a child or to have the child make the sexual penetration upon themselves. But I will.
Serena Evans, for the record, I would say that we interpret it the same way.
Okay.
So it's upon themselves.
All right, and I guess I read that the other direction, so maybe we have a third condition that we should consider. Because I know my wife being a district court judge now, having previously had the position of hearing the child or the juvenile sex offense cases, she will tell you all three conditions exist. We might want to address that. Thank you. That's all I have, Madam Chair.
Thank you. If I'm, for the record, Venetia Considine, I just want to follow up with that. Thank you for bringing that up, and thank you for sort of reinforcing why we've added section 2. Because I do believe that we need to have an advisory committee look at all this and update these because they are very old and need more effectiveness in our statutes. Thank you.
Thank you. And Madam Chair, I apologize. One other thing on its section 1, sub 4, we are talking about a category A felony, possibility of prison without possibility of parole for a 16 to 18-year-old. There's no reference to whether or not that individual has been direct reported to the adult court. And I believe the Supreme Court has come out, and the chair can speak to this. I believe they spoke about life without possibility of parole being unconstitutional for a minor. So we might want to look at that language as well. Anyway, I'm completely supportive of the bill. Just want to make sure we tighten it up and we address ambiguities so that there's no loopholes, there's no way to get around this. If they've done this, we nail them to the wall. Thank you.
All right, other questions from members of the committee? I now do want to clarify, and I think this actually may be more of a question for Mr. Anthony than for the sponsors of the bill, but as a person who prosecutes these kinds of cases, I utilize NRS 200.366, both subsections, to address pretty much every possible scenario. And my understanding is that subsection A, which starts on line 4, that offense, subjecting another person to sexual penetration, is what we traditionally think of as rape. That would be where the perpetrator inserts his or her fingers, penis, other object into the child's genital opening. Then the second part of subsection A forces another person to make a sexual penetration on themselves or another, is the part where an individual is forcing somebody to either sexually penetrate the perpetrator or use an object or their fingers to put it in their own genital opening. Sorry, that's for all people. And then part B is the same thing for a child. Is that accurate?
Thank you, Chair. Yes, that's absolutely correct.
All right, thank you. And not seeing any other questions, we will move to testimony in support of AB 214. There's nobody present in the room besides our presenters, so we will go directly to the phones. Please, Mr. Kyle.
4, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 214, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 648. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, Johnjones, here on behalf of the Clark County District Attorney's Office and the Nevada District Attorneys Association. We are in support of AB 214, and I want to thank Assemblywoman Considine for reaching out to us on this bill early. The purpose of this bill is to degender the sex assault statute, and we completely support that effort. But I do want to make clear on the record that the intent is not to substantively change any other part of the sex assault statute except to remove the gendered language. And I also want to say I appreciate Senator Pickard's question. Maybe in Section 1, Sub B, we should add themselves after the word child. And then additionally, in Section 1, Sub 5, Section 1, Sub 5, Sub B on page 3, where it says the persons, we should probably change that to the perpetrators to be consistent with the change that was made in Section 1, Sub A. But with that, Chair Scheibel, we are fully supportive of the intent behind the bill. We just want to make sure that we get the language correct, as Senator Pickard indicated. Thank you.
Thank you, caller. And if you've recently joined us this afternoon, we are currently on support testimony for Assembly Bill 214. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Once again, for anyone just joining us, we're currently on support testimony for Assembly Bill 214. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 080. Please press star 6 to unmute your microphone. Once again, caller with the last 3 digits, thank you so much. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. We support the concept of replacing the gendered language in this definition. We believe this is a simple step that will help make the bill more inclusive and protect more people. So we support it. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
Thank you. We will move to testimony in opposition to AB 214, please.
Thank you, Chair. To testify in opposition on AB 214, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 214, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Thank you. We will move to testimony in the neutral position on AB 214.
Thank you, Chair. To testify in neutral on Assembly Bill 214, please press star 9 now to take your place in the queue. Once again, to testify in neutral standing on Assembly Bill 214, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 080. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, this is Jim Hoffman again. I'm sorry, the Clark County and Washoe County Public Defender's offices had to hop off to another committee. They wanted me to convey that they are also testifying in support.
Thank you, Mr. Hoffman. We'll let the record reflect that the Washoe County Public Defender's Office and Clark County Public Defender's Office are in support of AB 214. Thank you.
Thank you, Chair. And with that, Chair Scheibel, there are no more callers to provide neutral testimony or support testimony at this time.
All right, thank you. Any final comments from our presenters?
Thank you, Venetia Considine, for the record. I just want to thank all the senators for listening to the bill and for asking any of your questions. These might seem like small changes, but they make huge impacts, and we look forward to improving these in the future. Thank you.
All right, thank you both. And I will now close the hearing on AB 214. I will now open the hearing on AB 405. We have presenters with us on Zoom for this bill, and whenever they are ready, they may go ahead.
Good afternoon, Chair Schiebel, Vice Chair Canizaro, and members of the committee and the committee manager. My name is Becky Harris. Presently, I'm an adjunct law professor at UNLV and teach Law 725, Gaming Law and Policy. Chair Yeager generously made a bill available for the law class. I'd like to provide the committee with some context about the genesis and development of AB 405. Prior to the start of the semester, gaming attorneys throughout Nevada were surveyed for changes that they felt would aid in the regulation of gaming. Those that were willing made suggestions to the class and provided context for how they felt their suggested changes would benefit the regulation of the gaming industry. After hearing the suggestions, the students selected an issue they wanted to study and advocate for. Chairman Yeager graciously agreed to include each student's issue in the bill. Students then wrote white papers and were required to draft a BDR for their issues, both of which were submitted to Chairman Yeager, and I understand that our draft BDRs were forwarded to LCB drafting staff. The students are also driving the advocacy for the bill and have reached out to over 55 stakeholders within the gaming industry in Nevada for feedback, including the Gaming Control Board. Today, you will hear testimony directly from two of the students, one of which has a conceptual amendment based on stakeholder feedback, and that's specifically the Gaming Control Board. Chair Schiebel, thanks for having us before the committee today, and if it is your pleasure, I would like to turn the presentation over to Tanner Britton.
Thank you, Professor Harris, and thank you, Chair Schiebel, and members of the committee for having us here today. As Professor Harris just stated, my name is Tanner Britton. I'm a third-year student at Boyd School of Law down here in Vegas in the Gaming Law Policy Seminar. Over the course of the past semester, myself and four other classmates of mine have worked hard to draft the sections, or the 5 sections of Assembly Bill 405. Today I'm here to speak more specifically on behalf of Section 5 of the bill, as I am the drafter of that section. The remaining 4 sections of the bill have since been amended, which are available on Amendment 325. With an additional proposed amendment to be heard today, who after I'm done presenting, I'll pass on to my classmate Erica, who's in here, who will talk about her amendments. So Section 5 of Assembly Bill 405 proposes an amendment to NRS 465.070 regarding the criminalization of match fixing. With the rise of legalized sports wagering nationwide, the issue of match fixing becomes more and more prevalent than ever in the eyes of law enforcement. Match fixing, by definition, of Sports Bribery Act, in concurrence with other research on the topic, occurs when a person, partnership, corporation, or I guess just an entity in general, attempts to influence the outcome of a sporting event. The most common means of doing so is bribery. However, threats of extortion and blackmail are also 2 other prevalent topics in the world of match fixing. The Marquette University Law Review has chronicled in detail over 30 gambling-related incidents between 1945 and 1998. Now, obviously, since then, with the repeal of PASPA and the more prevalence and acceptance of sports wagering nationwide, that certainly renders match fixing more of a hot button issue. It occurs at both the professional and collegiate level. However, it's disproportional where collegiate athletes are targeted by these potential match fixers. The issue, reeling it back to Nevada, I think a fixed match or even the possibility of a fixed match violates the integrity of these events and the integrity of events wagered on at sportsbooks in Nevada. The amendment to NRS 465.070 isn't the end-all, be-all solution to the issue of match fixing. However, it's a great start. And after reaching out to law enforcement and law enforcement agencies, it's good to provide clarification on the issue where it can be kind of a gray area. Assembly Bill 405, Section 5 would be unique, and that no other state really defines or has a statute defining and clarifying the issue of what is and is not constitute match fixing. Assembly Bill 405 would keep Nevada at the forefront of gaming regulation. At the same time, it also guides law enforcement in the protection of the integrity of matches and the integrity of the matches wagered on by sportsbook, while also protecting college athletes at the same time. With that, I'm happy to answer any questions now, or I would be happy to pass it on to my classmate Erica to speak on her section, and then answer questions after, whatever you feel is appropriate.
Thank you. Let's go ahead and have the next presenter also present the amendment.
Okay.
Good afternoon, Chair Scheibel, Vice Chair Canizaro, members of the committee, committee manager. For the record, my name is Erica Adler. I'm an LLM student in the Gaming Law and Regulation program here at Boyd, and I appreciate the opportunity to be here before you today. I will be presenting on the foreign gaming section of this bill, which was amended out in the Assembly Judiciary Committee, but since that hearing, I've worked with the board and we've come to an agreement on an amendment. The board is in support of this new proposed amendment to AB 405, and you can find this amendment on Nellis, and I will present on this amendment to you now. The new proposed amendment that we've agreed to would simply remove NRS 463.710 Section 1B, which requires that a Nevada gaming licensee who operates gaming outside of Nevada submit to the Gaming Control Board their systems of accounting and internal controls used in the foreign gaming operations and any amendments as soon as they're made. The removal of Section 1B would effectively reduce some of the reporting requirements that some licensees submit to Nevada Gaming regarding their operations in other jurisdictions. To provide a little bit of background, the Foreign Gaming Statute was enacted in 1977 in response to New Jersey legalizing casinos. The statute then required Nevada casinos to first get the Gaming Commission's approval before doing gaming operations in other jurisdictions. But in 1993, this requirement of first having approval was removed by the legislature and replaced with the foreign gaming reporting requirements that we see today in the statute. This change from an approval process to only reporting requirements was done because in the early 90s, there was a wave of jurisdictions legalizing gaming across the US, and Nevada gaming companies wanted to expand into those new markets, but the approval process took too long. The legislature found that instead of an approval process, reports would be a more efficient means of ensuring Nevada gaming companies operating in these new markets were doing so in accordance with Nevada's high gaming standards. But gaming is a lot more expansive today than it was in 1993, but the reporting requirements in this statute have not since been changed. The proposed amendment before you today would be an update to that statute. So as mentioned, after dialogue with the board after the last hearing, we've agreed to this proposed amendment, which would remove NRS 463.710 Section 1B and be a means to update how foreign gaming is reported by Nevada gaming licensees to the board. Thank you for your time, and we stand ready for any questions.
All right. Are there any questions? I don't have any questions. I appreciate both of you being here to present, and we will now open it up for testimony in support of AB 405.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 405, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 405, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
All right. We will move then to testimony in opposition to AB 405.
Thank you, Chair. To testify in opposition on Assembly Bill 405, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 405, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Thank you very much. We will move to testimony in the neutral position on AB 405.
Thank you, Chair. To testify in neutral on AB 405, please press star 9 now to take your place in the queue. Once again, to testify in neutral standing on Assembly Bill 405, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
Thank you very much. I will now close the hearing on AB 405. Thank you so much to our presenters for joining us today via Zoom to explain AB 405 to us. I think I mentioned shortly before your presentation that a number of our committee members had to leave to attend their next committee meeting, so I will be providing your contact information to them. They may be reaching out to you with questions that they have when they've had a chance to review the recording of this hearing and read the bill and do their other due diligence. So thank you again. We are closing the hearing on AB 405. That takes us to the last item on our agenda, which is public comment. I don't see anybody present to give public comment, so we will go directly to the phone lines. Please, Mr. Kyle.
Thank you, Chair Scheibel. We are currently on public comment. If you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. Once again, if you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. And Chair, the phone lines are open and working. However, there are no callers to give public comment at this time.
All right, thank you for your help. That concludes our meeting for today. We'll be back again tomorrow at 1 p.m. Until that time, we are adjourned.